The Supreme Court just issued a ruling protecting the First Amendment rights of gun organizations like ours. The case is NRA versus Volo. It arose out of the New York financial regulators pressuring banks and insurance companies to stop doing business with the NRA. The Supreme Court this week ruled that was a violation of the First Amendment, and they were right, it absolutely is. And the Supreme Court called out the Second Circuit for ruling incorrectly in this case, and for twisting the Supreme Court's own previous precedent to rule against the First Amendment. Does that sound familiar to anybody? The Supreme Court basically said, nope, you lower court judges know what we did, you got it wrong, we're overruling you. So we see the Supreme Court does know how to enforce its own precedents. Now, this is great news for gun rights supporters and really for liberty activists everywhere, because one of the left's favorite tactics is to try and shut down their political opponents. But we at the National Association for Gun Rights have seen so many instances over the years of the left going after the Second Amendment by attacking the First Amendment. And that's why we filed an amicus brief in this case, asking the Supreme Court to rule in favor of the NRA's free speech rights. I want to say initially that the Supreme Court did not break new ground here. They simply reiterated what they had already said in a previous First Amendment ruling. But the First Amendment violation was so egregious here that if the Supreme Court had ruled the other way, it would have been a huge blow to existing free speech protections. Plus, as I mentioned, we have here a very clear case of the Supreme Court enforcing its own precedents. There's actually nothing preventing a lower court from ruling however they want to, except the threat of getting overturned by the higher court. That's why when the Supreme Court issues a good ruling, it's meaningless unless they're also willing to follow through with it. That's exactly what's at stake with our own Supreme Court challenge on so-called assault weapons bans that is currently pending as I film this before the Supreme Court. And that is why we hope they will take it and enforce the Bruen ruling on a nation full of lower court judges who are going to ignore Bruen for as long as the Supreme Court will allow. That's one of the reasons I was so thrilled about this week's ruling in Volo. The Supreme Court did the right thing here. They saw a lower court twisting their own precedent in order to trample a Bill of Rights guarantee. And they stepped in and unanimously, 9-0, overturned the Second Circuit's ruling and outlined exactly where the lower court had gone off the rails. And the First Amendment has been preserved and upheld. Now, we hope the court will do this for the Second Amendment. But while we wait, this ruling is something to celebrate. The background of this case started a number of years ago with the New York financial czar, Maria Volo. She was wildly anti-gun, and she went after the insurance providers that were underwriting the NRA's insurance policies. Now, in the third-party insurance marketplace, there were a number of compliance violations. This was not unique to the NRA, but Volo decided to only enforce the law when it came to the NRA. So basically, it was selective enforcement aimed at silencing a gun group. And the insurance companies underwriting the policy were like, sure, fine. I mean, absolutely. We'll take a deal where we only get the law enforced in this one instance if we just back away from the NRA. And so that's what they did. And emboldened by that success, Volo then turned her fire on the banks. Now remember, she is the financial regulator, right? So she has a very clear, very powerful regulatory role here. She turns to the banks and says, y'all need to think about your social responsibility and reputational risk, and you need to revisit your relationship with the NRA and with other similar gun organizations like ours, the National Association for Gun Rights. I also want to emphasize that there were no compliance issues for her to use as leverage in this case. She just didn't like the banks doing business with gun groups. Now, that is a common tactic on the left. It's becoming increasingly common. And as we have an increasingly cashless society, access to banks is one of the biggest threats to freedoms that we face. And so, the NRA very properly brought a lawsuit against Volo. They were alleging First Amendment violations, and they're right, because the First Amendment includes your freedom to freely associate with organizations like the NRA and with us. And if a government official decides that you are a disfavored group because they don't like your speech, and then they use the regulatory power of the state to lean on other people and bludgeon them into dropping you as a customer, that is one of the most egregious ways you could violate the First Amendment. So the NRA very properly sued, and the district court refused to grant a motion to dismiss from New York. The district court said, no, we think you have enough of a case here to go forward. So New York appealed to the Second Circuit. The Second Circuit then said, no, we're going to throw the case out. And then the NRA appealed to the Supreme Court. And that's where the case has been. Now, the interesting thing here is that in their arguments to the Supreme Court, New York actually said, well, yeah, but the government also has a First Amendment right to speak out against gun rights. No, it doesn't. The First Amendment exists to protect citizens from the government, not the other way around. Gun grabbers in the government do not get to trample the First Amendment rights of gun owners or of anybody, and then claim they're allowed to by the First Amendment. And that is exactly what we told the Supreme Court in our own Amicus brief. In our brief, we said this: the court should take this opportunity to clarify that the government speech doctrine does not create a separate set of free speech rights to be balanced against those of private speakers. And we emphasized that the First Amendment includes the right of association by, for instance, joining the National Association for Gun Rights. And then we poked holes in New York's claim that Volo's actions were protected under some sort of government speech right, and emphasized that that argument would allow all sorts of viewpoint discrimination on the part of the government, which is exactly what happened in New York. And by the way, we're going to put a link to that amicus brief we filed in the case in the description below if you'd like to read the whole thing. Now, this week's ruling from the Supreme Court was very simple and very straightforward. And they said this: as superintendent of the New York Department of Financial Services, Volo allegedly pressured regulated entities to help her stifle the NRA's pro-gun advocacy by threatening enforcement actions against those entities that refused to disassociate from the NRA and other gun promotion advocacy groups. Those allegations, if true, state a First Amendment claim. At the heart of the First Amendment's free speech clause is the recognition that viewpoint discrimination is uniquely harmful to a free and democratic society. A government official can share her views freely and criticize particular beliefs, and she can do so forcefully in the hopes of persuading others to follow her lead. In doing so, she can rely on the merit and force of her ideas, the strength of her convictions, and her ability to inspire others. What she cannot do, however, is use the power of the state to punish or suppress disfavored expression. And there the court drew a bright line distinguishing when a government official actually can speak out on something versus when government actions actually trample on the First Amendment rights of citizens. And the ruling went on to say this: nothing in this case gives advocacy groups like the NRA a right to absolute immunity from government investigation or a right to disregard state or federal laws. Similarly, nothing here prevents government officials from forcefully condemning views with which they disagree. For those permissible actions, the Constitution relies first and foremost on the ballot box, not on rules against viewpoint discrimination, to check the government when it speaks. Yet where, as here, a government official makes coercive threats in a private meeting behind closed doors, the ballot box is an especially poor check on that official's authority. Ultimately, the critical takeaway is that the First Amendment prohibits government officials from wielding their power selectively to punish or suppress speech, directly or as alleged here, through private intermediaries. It's an outstanding ruling. It's exactly the way we had hoped that the court would rule. It's the way we asked them to rule. And like I said, it was 9-0, a massive victory for free speech rights. Now, this case came before the court because New York had filed a motion to dismiss, much like Heller, actually. That's what the Supreme Court was ruling on. This does not end the case. It just keeps the case alive, and now it goes back to the district court where they'll go through a discovery phase and a trial and final judgment. And then if the district court gets that wrong, or if New York doesn't like the ruling, then it will go back through the appellate process and perhaps back to the Supreme Court. But hopefully, the lower courts will take note of what the Supreme Court said here and will basically treat that as dispositive, at least on the First Amendment side of the issue, because that's what they've done here. They've dealt very summarily with the First Amendment side of this. As you know, we currently have our own case that's pending before the Supreme Court. We had our third conference date yesterday where the Supreme Court was debating among themselves whether or not to even take our case. And we sincerely hope that the Supreme Court will take the case, will do the same thing, will overturn the lower court's outrageous ruling that trampled all over the Bruin precedent. So we will know more in the next week ahead, and we will certainly keep you posted as soon as we have news. For now, fingers crossed that the Supreme Court we'll remember that the Second Amendment is not a second-class right, subject to an entirely different set of rules than the other Bill of Rights guarantees like the First Amendment. But for today, we celebrate this massive First Amendment win. So stay tuned for updates, and don't forget to like this video and subscribe to our channel for updates. Thanks so much.